Hello Innoventors, I'm Karima Gulik, Patent and Trademark Attorney at Innovent Law, and today I wanted to talk about protection of cannabis brands and how to make sure that your brand does not go up in smoke. Over the past few years, a lot of businesses have grown their cannabis businesses and cannabis brands, and to spend that much time and money on clever branding and marketing and not protect it would be an utter waste. So I wanted to talk about what you can and can't do. As you know, cannabis is a substance that is still controlled under the Controlled Substance Act. And because the United States Patent and Trademark Office is a federal office that goes by federal laws, you cannot protect anything that deals with the actual cannabis flower or bud itself. So if you're selling the actual cannabis, you're not going to be able to get federal protection for that. A few other things that you cannot do. So even if it's a byproduct of that, so if it's grounds or anything like that, you're still not going to be able to get a federal protection for it. However, if you're doing any ancillary goods or services, you can protect those. So anything that does not touch the bud or the flower is protectable federally. So for example, if you're doing consultation services, one-on-one, helping people finding the right dosage, that's part of your business. If you're helping cannabis businesses advertise, if you have a software application like WeedMaps, for example, helping locate, advertise other cannabis businesses, then you can get those registered. As a matter of fact, if you can look right here, you're going to see that all the different registrations that WeedMaps and other similar marks have registered federally. One thing I do not recommend doing: don't go starting a clothing brand just for the sake of preserving your rights for your cannabis brand. Unless clothing is a big part of your business or you anticipate it to be a big part of your business, just simply getting your mark protected under the clothing class won't really help you much down the road if and when cannabis becomes federally legal. Now, if you're selling gummies, if you're selling edibles, if you're selling the actual bud or flower, here in California, you can file a California registration and protect your brand under those classes. One thing about California trademark application is, unlike the United States Patent and Trademark Office and federal registrations, where you can file an intent to use application even though you haven't started selling yet. You can file an application and then submit proof down the road of how you're using the mark. Well, you cannot do that for California trademarks. You have to have use in commerce before you file those applications. So if you are in one of the states where you can actually register your mark on a state level, I would highly recommend doing that and getting a date of first use on that application, getting a registration with your state to cover all the products that might not be protected federally. I hope this helps. If you are in the CBD business, please make sure to watch the following video where I dive into what you can and can't do with CBD marks. Until next time.